Well, greetings, everyone. Thank you for joining today's session. We'll be discussing intellectual property disputes in England and Wales, how they arise, where they can be heard, and of course, how they can be settled. My name is James Whittaker. I am the founding member of Whittaker Law, a specialist media and entertainment practice in the UK. So, intellectual property is at the heart of innovation and creativity, whether in technology, in media, fashion, pharmaceuticals, you name it. Protecting IP is vital for businesses and individuals alike. However, despite best efforts, disputes are often inevitable, and when they are, they can become very disruptive. So today, we're going to explore the framework and structure within which IP disputes arise and can be resolved within the UK, what mechanisms are available to settle them, and the key legal challenges and other challenges that businesses, creators, and litigators need to navigate. We'll look at how IP disputes are dealt with and resolved, whether through litigation, through alternative dispute resolution or ADR, as well as the various commercial considerations that come into play in this type of dispute. By the end of the session, I hope you'll have a clear understanding of the processes by which IP disputes are typically resolved in the UK, the key steps in litigation or indeed in ADR, the common challenges the parties face when trying to settle disputes, and the latest trends shaping IP dispute resolution. So let's get started. A brief word on Brexit, if I may, because it is highly significant in the context of IP disputes and IP law in this jurisdiction in England and Wales more generally. As you'll recall, the UK officially left the EU on 31st of January 2020, with a transition period ending at the end of 2020, during which time IP rights broadly remain largely unchanged. Since early 2021, when the Trade and Cooperation Agreement came into provisional effect, we've seen gradual divergence and the start of a shift away from EU law. That agreement, rather than applying anything new, essentially set the current levels of IP protections applying in the EU as the baseline to which both the EU and the UK remain committed. Now, a key development has been the retained EU Law Revocation and Reform Act that you see referenced at the bottom of the slide there. This came into effect in early 2024. The Act crucially abolished the principle of the supremacy of EU law, meaning that UK courts no longer have to follow EU precedents. While this could have led to a distinctly English approach to IP disputes, and it may still do, thus far, courts have mostly continued to align with EU case law. This may change over time, but we'll see shortly how this is playing out in settling out IP disputes.